Doc Talk. Yeah, we keeping it smooth. Your favorite paralegal got the legal groove. From the stars in the courtroom to your cousin's case, we breaking it all down. No rush, just pace. Hey everyone, welcome back. My name is Cassandra, aka Legal Doc Talk. Wait, my name is Cassandra, aka your favorite paralegal. And this is Legal Doc Talk. Hey, y'all gonna get it raw every single time. But we're gonna tap into I know you guys have probably already seen on social media the little reel that I put in regards to Suzanne Wooten, who was wrongfully convicted of a crime. And it is very y'all, when I read this a lawsuit to you guys, I read just a brief. I knew what happened, and it's crazy that this was brought up to my attention. So while I work, I listen to various people on various platforms. And today I was on TikTok, and I was on one individual's TikTok, and the what is her name? The Court of Public Opinion, the Public Opinion Court. What's her name? Miss Thelma. She was a former prosecutor here in Dallas County, right? And she spoke about Suzanne Wooten, and I was like, why does that name sound so familiar? Then she started talking about what happened, and I was like, wait, what? So you telling me that Collin County's been doing this? And the lawsuit, if y'all have tapped in to that Collin County DA's office lawsuit against Greg Willis and Bill Worski, I did a four-part because it was a lot. So I did a four-part episode. Please go watch that so you can understand how dirty those people are, right? But this that I am about to read to you guys clarifies everything. Now, I am not the one for conspiracies. And I'm sorry if y'all hear a fan in the background, y'all, it is extremely hot in Texas. Today was freaking, I don't know. I think it said 109, but it was 100 and it felt like 118, baby. I can't. Texas, I don't know what's going on. We got a heat wave going. But anywho's back to what I was saying. So when you, let me just click on it. I don't even know how to explain it. All I know is Collin County has been doing this. I want y'all to take a look at who Miss Suzanne Wooten sued. Yes, you see it, John Roach, but not Junior. It was Senior. Do you know why it was Senior? Because Senior Judge John Roach, well, I don't want to say judge, but DA Roach, or however you want to call him, he was a district attorney. And if you tuned into the Greg Willis Bill Worski lawsuit, we already know what the DA, what their capability is. They're the ones who say, okay, we're sending this to a grand jury. This judge, Judge Roach Daddy, is the one who willingly participated in doing what they did to Miss Suzanne Wooten. Right now, she does have her law license back. She does. She has her own firm, and she's doing well. And I remember hearing this case a long time ago, but back then I was just, a paralegal just working at. Well, was I a paralegal back then? I think I was, or a year before. I can't remember. I think it was a year before I actually became a paralegal. But it was more of like a robotic paralegal. Like, yeah, I worked here. I'm gonna do this, do this, do this. And I'm so grateful I am where I am today. But anywho's, these people concocted a whole story against this lady, all because she won. But it goes to show the the vibe, the environment, and whatever else, what they really think about women. They feel that women can't be in positions such as being a judge, especially if they're running against a male, a conservative male, you know? So that was really a big thing for them. And no telling what little, how can I say this? Like, okay, if the dude won, judge, then that means we can definitely get cases in his court and we could do this, and this is how my mind is thinking, right? But going back to what I was saying previously, I don't do conspiracy theories. You hear these things, but I don't actually believe it until I can verify it myself. I can see it. And for Miss Wooten to go through what she went through is mind boggling. But without further ado, let me quit yapping and let's get into this lawsuit. It is 32 pages, so this is going to be one of those straight reads. So take your notes, take your notes, take your notes. And a lot of people are going to be like, well, why is this relevant? Yes, we saw what happened in Carmelo Anthony's case, and that is a separate issue that we are all coming together to ensure that he gets a fair trial. But we don't want what has happened not to just Carmelo, to anybody that has a case in Collin County to go through what anybody else has gone through, because this is crazy how corrupt this office is. So let's get into it. So we have Miss Suzanne Wooten, who was a judge at the time. She brings action, and this was actually filed in the Eastern District of Texas, in Sherman. Sherman is way up there near the Oklahoma border. But anywho, she brings this action pursuant to 42 of the United States Code, Section 1983, 28 of the United States Code, Sections 1331, 1343, and the 4th and 14th Amendments to the United States Constitution, to vindicate her right to be free from wrongful arrest and prosecution, and files this, her original complaint, complaining of and about John Roach Sr., Christopher Melner, Collin County, Texas, Gregory Abbott, and Harry White, here and after collectively referred to as defendants. Now, if I am not mistaken, I believe that Harry White, let me get, let's see what he was, because I forgot. Harry White. He was a defense attorney. Wait, he was a defense attorney. Hold on. I was like, the plot thickens, and I like to give my raw reactions to this. You know what? I'm doing all this. I'm gonna share this screen so y'all can actually see what I'm looking at. Okay, bam. We in there like swimwear. If I can go back. All right, set those. All right, so this is the four. Okay, Judge, I keep saying Judge. John Roach Sr., former Collin County District Attorney. Abbott, he was the Texas Attorney General at that time. That's why I want for you guys to kind of see, the timeline on this. Chris Melner was Collin County's Assistant District Attorney. So he was working with John Roach Sr. And then Harry White, former prosecutor for Attorney General's office. Okay, that makes sense. All right, so everybody see that. So Harry White was a former prosecutor. Chris Melner was a former Collin County Assistant District Attorney, equivalent to what Bill Worski is. John Roach is equivalent to what's that boy named Greg Willis is. And then we have Greg Abbott, who is, now we call him Governor Hot Wheels, but he was the former Texas Attorney General. Okay, so everybody got that out the way, right? Cool. Cool beans. So let me take this off. Let's hide that. Okay. Going back to the complaint. Mm-mm-mm-mm. Intro. Plaintiff Susan H. Wooten was wrongfully arrested, charged, and convicted of multiple contrived counts of conspiracy to commit engaging in organized criminal activity, money laundering, and tampering with a governmental record based on a false and legally untenable allegations. Defendants John Roach Sr., Christopher Melner, Collin County, Texas, Greg Abbott, and Harry White conspired to wrongfully obtain an indictment and prosecute plaintiff by inventing and perverting law, misleading judges and juries, and taking apart plaintiff's life and career one piece at a time. Beyond the fact plaintiff did not engage in the conduct alleged by defendants, defendants knew full well the law did not proscribe any of the alleged conduct. In an attempt to ensure that plaintiff was convicted despite her innocence and knowing she committed no criminal act, defendants intentionally misrepresented the law and facts and secured a wrongful conviction of plaintiff. Plaintiff was forced to step down from her judicial position. Her license to practice law was suspended for 10 years by the State Bar of Texas Board of Disciplinary Appeals, compulsory action due to convictions, and her reputation and career were devastated. All for the sake of political retribution for defeating the incumbent judicial candidate who preceded plaintiff on the bench and for not playing ball with the powers that be. Ultimately, the criminal case against plaintiff fell apart when her alleged co-conspirators was held by the Texas Court of Criminal Appeals to be actually innocent and that there were no evidence of any wrongdoing. On May 24th, 2017, after spending 5.5 years under community supervision, plaintiff was exonerated by writ of actual innocence. Unfortunately, the damage had already been done. As noted in the order granting the writ of actual innocence, plaintiff's civil rights had been violated. Plaintiff now sues to recover for the harm done to her by the corrupt government agents who targeted her unjustly. And this talks about the jurisdiction. Mm. All right, that was the parties. All right, let's get to the good old facts. On March 4th, 2008, plaintiff Suzanne Wooten defeated the incumbent judge Charles Sandoval in the Republican primary election for the 380th District Court judge in Collin County, Texas. In the history of Collin County, Texas, an incumbent district judge had not been challenged for re-election until plaintiff won the primary by a landslide. The following day, Judge Sandoval went to the Collin County District's Attorney Office to complain about Judge Wooten. Judge Sandoval felt there was no way Judge Wooten could have won the Republican primary election without cheating, insinuating to the CCDAO that they needed to find a crime. The CCDAO decided to conduct its own investigation into Judge Wooten's campaign and begin grand jury proceedings to aid in their investigation. Law enforcement did not initiate this investigation, nor did law enforcement aid in this investigation. This investigation originated and was subsequently conducted by the CCDAO and later by the Office of Attorney General, acting in conjunction with the CCDAO. The investigation lasted over 2 years before Judge Wooten was initially indicted on October 14th, 2010. 9 months Another 9 months went by before the final indictment against Judge Wooten was filed on July 14th, 2011. These This case involves three other co-defendants. Two of the co-defendants were a married couple named David Frederick Carey and Stacy Stein Carey. collectively the Careys. The third co defendant was James Stephen Spencer, a consultant who assisted the Careys with other matters and was employed by Judge Wooten as her media consultant during her judicial campaign. Each of the indictments for the Careys and Judge Wooten are substantially identical, as the allegations track the same statutory language and same alleged scheme of conduct. The CCDAO and the OAG moved forward with a prosecution of Judge Wooten, knowing there was no probable cause and that a crime had not been committed. The theory of prosecution was that the Careys gave itemized monetary contributions to Judge Wooten through Judge Wooten's media consultant, Spencer, in exchange for Judge Wooten's decision to proceed with a campaign to unseat the incumbent judge of the 380th Judicial District Court. The problem with this theory of prosecution is that, even if true, these actions would not be illegal, and the CCDAO and OAG knew that these actions were not illegal when they moved forward with the prosecution. The CCDAO had ulterior malicious political motivations for prosecuting Judge Wooten. The CCDAO wanted Judge Wooten off the bench because the CCDAO disagreed with Judge Wooten's rulings in criminal cases. This motivation is evident from a myriad of evidence, including a CCDAO internal email and the redaction of incriminating statements before a decimation of that email as a response to a public information request. The pressuring of witnesses, destruction of evidence, and clear misuse and abuse of the grand jury process. Additionally, it was widely known in the legal community that the CCDAO had a special crimes division headed by defendant Melner who used heavily handed tactics and strategies to investigate, intimidate, and often indict those who were his enemies. As detailed below, numerous lawyers, elected officials, and courthouse staffers were targeted by CCDAO during the 2 terms former District Attorney Roach ran the CCDAO and employed defendant Melner. The OAG knowingly aided the CCDAO in accomplishing their goals by ways of prosecuting Judge Wooten when it was clear a crime had not occurred. After Judge Wooten was unconstitutionally convicted at trial, she was exonerated through the granting of her 11.072 writ of habeas corpus, declaring actual innocence as a matter of law with the 366 Judicial Court in Collin County, Texas, on May 24th, 2017, with convictions deemed void. What is ab initio or initio by the district court. The court relied upon the Court of Criminal Appeals ruling in Stacey Stein Carey versus State and in David Carey versus State. So they use those two. And that is actually the highest court. The Court of Criminal Appeals, that means that it skipped. And I'm not sure if Um, I don't know if Sherman is part, but whatever it is, you have the Court of Appeals and then you have the Texas Criminal Court of Appeals. So that's the highest appeals court. And they used Miss Wooten's co-defendants cases in her case to get her pretty much off. Oh my gosh. I'm glad that they did that. But anyway, anywho's that the allegations in the indictments, even if true, were not crimes under Texas law as a matter of law. As a result of the baseless investigation, prosecution, and conviction, Judge Wooten was forced out of her position as a judge of the 380th Judicial District Court, exactly as the CCDAO and the OAG planned. This action is brought pursuant to 42 U.S. Code, Section 1983, the United States Constitution, Texas statutes, and common law. Now, let's talk about the Office of Attorney General. Like, how in the world did y'all get into this, Mr. Greg Abbott? At the time of the CCDAO's and the OAG's investigation and prosecution of Judge Wooten, Greg Abbott, Governor Hot Wheels, was the attorney general for Texas, similar to Kim Paxton, right? Anyways, in December of 2008, CCDAO Chief of Special Crimes Unit Chris Melner requested the assistance of the Criminal Prosecution Division of the Office of the Attorney General of Texas in investigating a case against Judge Wooten. According to Defendant White, Defendant Melner requested Defendant White because Defendant Melner had experience working with Defendant White on previous occasions and that Defendant White had expertise prosecuting election violations. Defendant Abbott, the OAG, allowed his office and staff, including Defendant White, to assist the CCDAO in the investigation into Judge Wooten. The OAG had additional greater resources for the CCDAO and was able to provide Attorney General Auditor, who is that, Kyle Sweetheart, along with Defendant White. Defendant White would be assisting the CCDAO as a special assistant district attorney, while the CCDAO would maintain control of the investigation. In an interview with FBI investigators in mid July of 2010, Defendant White confirmed that he became involved in the investigation of Judge Wooten in December of 2008 and stated to the FBI that he did not know why the CCDAO did not recuse themselves at the beginning of the Judge Wooten investigation. Defendant White misrepresented to the FBI that he had been appointed to attorney pro tem in February of 2010. Further, Defendant White informed the FBI and the CCDAO through thought that once wait, hold on. Further, Defendant White involved the FBI that CCDA thought that once Greg Willis was elected Collin County DA, the Wooten investigation would be discontinued, if not transferred to the AG's office. It will become clear that the CCDAO wanted to maintain control over the malicious investigation and prosecution of Judge Wooten under the guise of OAG leading charge. Y'all, we got to keep in mind that the CCDAO is Judge John Roach's daddy, Roach Sr. I have to throw that in there. In late July of 2010, 8 days after Defendant White meeting with the FBI, Defendant Melner and Defendant Roach requested that the Office of the Attorney General and its designee, Defendant White, become the attorney pro tem for the Judge Wooten investigation. The order of recusal and appointment attorney pro tem signed by Judge Mark Ruch, I don't know how to say that, on July 22nd, 2010, included a provision that the CCDAO may render such prosecutorial support, investigative aid, and other assistance as the attorney pro tem deems proper. This gives control of the investigation to the OAG. However, Defendant White had been working as a special assistant district attorney with the CCDAO since December of 2008 and was formally deputized as an assistant district attorney for Collin County in September 2009 when this changing of the guard occurred in July of 2010. Defendant Abbott failed to intervene when the investigation his office was continuing to be a party to was clearly unconstitutional, illegal, and without merit. Huh. So that's how Greg Abbott, aka the Attorney General at that time, got into this lawsuit. Now let's go about the abuse of the grand jury process. Because the DA has to submit this to the grand jury. So let's check this out. Let's see what they're talking about. In September of 2008, the first known grand jury subpoena was issued as a result of a criminal investigation against Judge Wooten before Judge Wooten took the bench in January of 2009. At least 9 grand jury subpoenas for documents were issued in the fall of 2008 alone. In September of 2009, defendant Melner started issuing grand jury subpoenas for Judge Wooten's employees, numerous people who contributed funds to Judge Wooten's campaign, and other persons related to the campaign. The CCDAO used at least 5 grand juries to investigate this criminal case against Judge Wooten. More specifically, the grand juries of the fall of 2008, spring of 2009, fall of 2009, spring of 2010, and fall of 2010. 4 of the 5 grand juries were used to subpoena bank records, phone records, credit card documents, personal records, emails, and various campaign-related vendor information. 3 of the 5 grand juries was used to subpoena witnesses. District Judge Chris Oldner presided over one of the grand juries in the fall of 2009. That grand jury wrote a letter to Judge Oldner explaining that they felt the case against Judge Wooten was unnecessary, a waste of taxpayers' dollars, and that no crime had been committed. In April of 2010, the FBI began investigating 3 attorneys in the CCDAO. District Attorney John Roach, First Assistant District Attorney Greg Davis, and Chief of Special Crimes Unit Assistant District Attorney Chris Melner for allegations that the CCDAO was misusing the grand jury to create politically motivated investigations against Judge Wooten and Collin County District Attorney candidate Greg Willis. That is crazy. Yeah, because if y'all watch my video, I did say that they were previously investigating Greg Willis. Dun dun dun. So, District Attorney Roach was conducting an investigation against Greg Willis, who he was a judge but wanted to run as district attorney. Y'all, this is crazy. The drama in Collin County. The FBI investigation involved numerous interviews. One of those interviews was with the grand jury member DJ, who was on the grand jury that heard Wooten and Willis investigations. Oh, I wonder what that investigation. Oh, I gotta do my homework. I wonder if there's any filings. But anywho, let me get back. Concentrate. Stay on subject. According to DJ, District Attorney Paul Unfoso usually presented the cases to the grand jury. The exceptions were usually cases involving crimes against children in which the specific ADA assigned the case made the presentations. There were 2 exceptions. These exceptions were articulated as being the DA's top 2 cases and were presented by ADA Davis and defendant Melner. The cases involved Collin County judges Greg Willis and Judge Wooten. DJ stated that the 2 cases against Judge Greg Willis and Judge Wooten were completely different from all other cases heard by the grand jury. The presentation of evidence for the 2 cases was strange. The prosecutors, Davis and defendant Melner, often set the stage for a witness by telling the grand jury what the witnesses would testify about. The prosecutors often made comments to both DJ individually and to the grand jury as a whole, which led DJ to believe both cases may have had underlying personal issues. DJ described the case against Judge Wooten and Judge Greg Willis as being needlessly drug out, as no serious evidence was ever presented, even though prosecutors kept promising that a star witness would arrive who would make sense of it all. These 2 cases were handled totally different from other cases, which moved along more rapidly. DJ and other grand jury members started articulating to Davis and defendant Melner their concerns as to the DA's office having conflicts of interest with these cases. DJ told the prosecutors that the investigation seemed more like a political witch hunt. DJ asked Davis if his boss, CCDA John Roach, knew what the prosecutors were doing. Davis responded that of course Roach knew that that was why they were presenting the cases and that Roach did not like this person, Judge Greg Willis. After that comment, Davis tried to backtrack and told DJ to forget that DJ heard that comment. Y'all know my mind is going left field now. Now, y'all get my raw reaction. So, John Roach Sr. don't like Greg Willis. Cause I wonder, was Greg Willis even in the courtroom with in Carmelo's case? Has Greg Willis ever gone in the courtroom before, or does he avoid it at all costs? That's why we had Worski and the other members, Dewey Mitchell and all them. So y'all, so John Roach Sr. don't like Greg Willis. Baby, this is tea. Defendant Melner kept promising that the grand jury would hear from a star witness. This never happened. Defendant Melner kept bringing in DA office employees whose testimonies added nothing new to what had already been presented. He seemed to be dragging out the investigation. DJ surmised that it was all politically motivated. The grand jury asked defendant Milner to hear Judge Wooten's criminal case, but defendant Milner refused to present the case to the grand jury. This was done because in the event the grand jury no billed Judge Wooten, defendant Milner would have had to provide substantial evidence to reopen the case. By not presenting to the case to the grand jury before its term ended, defendant Melner could just continue investigating Judge Wooten when the next grand jury teams begin. Defendant Melner was grand jury shopping. He was pretty much trying to figure out which grand jury he can actually bait in order for them to say, okay, we're going to submit this bill. Oh my gosh. On June 24th, 2010, the Collin County Grand Jury voted 8-3 in favor of a 90-day extension to their 6-month term. The the Collin County Grand Jury, that's what we're going to call them, wanted to hear additional findings in the Judge Wooten investigation. Collin County District Judge Ray Willis, boy, boy, boy. I'm pausing. Judge Raylis, however you say his name, he was presiding over the grand jury at that time. He denied the grand jury the 90-day extension because he felt the Attorney General prosecutor was working on behalf of the CCDAO and not the OAG. What? Collin County District Judge, and if y'all don't know who Ray Willis is, right now today he's the first administrative regional judge, and he is the one who assigned Judge Sid Harley over the motion to recuse that was filed in the Carmelo Anthony case. Baby. All right, Collin County District Judge, and presiding grand jury judge Chris Oldner admitted to Judge Wooten and the Collin County District Court Judge Mark Roosh that he, Judge Oldner, had 2 separate meetings with Davis and defendant Melner regarding the substance of their investigations against Judge Wooten and Judge Greg Willis. Judge Older informed them that he did not believe that Davis and defendant Melner had presented information that warranted an investigation against Judge Wooten or Judge Greg Willis. Defendant Melner and Davis' responses were that they would eventually gather enough information to indict Judge Wooten and Judge Greg Willis. They just needed more time to investigate. Prior to the defendant Melner being employed at the CCDAO, grand jury investigations were initiated by law enforcement organizations. There were no independent investigations initiated and conducted by the CCDAO. However, when defendant Melner started his employment with the CCDAO, the Special Crimes Unit was formed and grand jury cases began to be initiated from within the Special Crimes Unit. So, out of this section, they was grand jury hopping. That's what they were doing. You can't make none of this shit up. Abuse of power for political gain by CCDAO and OAG members. Rumors of the CCDAO investigation were widespread at the courthouse starting in mid 2009, and defendant Melner would often sit in the back of Judge Wooten's courtroom watching her when he had no case on her docket. Judge Wooten's financial matters with her longtime banking institution started changing in mid 2009 based upon its receipt of grand jury subpoenas for her personal financial records, and persons unknown to Judge Wooten were seen to drive by and photograph her home and family. Boy, these people were sick. Defendant Melner and I say Judge Roach's daddy played a major role in this. Greg Abbott played a major role in this. I kid y'all not, I did not know how deep this shit went. Defendant Melner and Judge Roosh had a close relationship. Judge Roosh told Judge Wooten that defendant Melner informed him, Judge Roosh, about details of the Judge Wooten and Judge Greg Willis grand jury investigations. Defendant Melner explained to Judge Roosh that he wanted to leave the CCDAO with a bang. Judge Roosh had mentioned to Judge Wooten that defendant Melner was looking to prosecute Dallas District Attorney Craig Watkins on a constable investigation. What? Further, Judge Roach told, rest in peace, Greg Watkins. But further, Judge Roach told, told Judge Wooten not to worry about the Judge Sandoval, but to worry about the army coming after her. I, I'm speechless. On October 1st, 2009, Judge Wooten attorney, and y'all have to be in Dallas. Y'all have to be like in Texas to understand this. Like, I don't know where y'all listening from, but right now it's just like I hear stories, right? I hear stories, but not of this magnitude. Like, I knew these folks was dirty, and I'm just thinking, it's the judges and it's the attorneys, that come into the courtroom. I would never in a million years would think that the attorney general, the state of Texas, and Collin County would had a role. This is crazy. So you in another county, and now you talk about you want to go prosecute Craig Watkins over a constable investigation? I gotta look that up because I need to see what the beef was with that one. But let's get back into it, guys. On October 1st, 2009, Judge Wooten's attorney, Peter Schultz, contacted defendant Melner regarding the CCDAO investigation of Judge Wooten. Defendant Melner demanded that Schultz meet with him pronto. Schultz met with defendant Melner in the Collin County Courthouse, and in that meeting, defendant Melner told Schultz that Judge Wooten had 1 week to resign, or she was going to be facing indictment and would lose her house, law license, her family, her reputation, and that he would put her in prison for a long time. When Schultz inquired about the basis for Judge Wooten's resigning, defendant Melner replied that she knows what she did and that the judge, defendant Roach, insisted that he be called Judge Roach. What? Bro, you ain't even no judge. You was just a district attorney. Would look favorably upon her if she resigned. Judge Wooten declined to adhere to defendant Melner's demand and continued her duties as sitting district judge. How you gonna be like you're the DA, but you want somebody to call you Judge Roach? A meeting took place between defendant Melner and Spencer. During this meeting, defendant Melner asked Spencer to sign a blank confession. Defendant Melner explained that he would tell Spencer what he was going to say in the confession after Spencer signed it. What? Spencer declined to sign the blank confession because, baby, what? You're not about to attach my name to nothing. CCDAO investigator Steve Goodman passed on the information that evidence pertaining to Judge Wooten and Willis investigations was being destroyed within the CCDAO. Let me see. Mr. Goodman has since claimed in an interview with the FBI to be unaware of any destruction of evidence. I bet. On September 21st, 2009, Schultz issued a public information request to the CCDAO for any communication the CCDAO had regarding policies and procedures when presenting cases in Judge Wooten's court. On December 16th, 2009, the CCDAO responded to Schultz's request with a copy of an internal email from Davis to ADA Ben Smith and CCDA Roach, which contained a brief paragraph congratulating Smith and ADA Linda Kirkland for their work on a mortgage fraud trial. On August 28, 2010, the FBI investigation into the CCDAO ended after defendant White told FBI investigators that the CCDAO had legitimate investigation against Judge Wooten and that the OAG expected to receive a grand jury indictment in the near future. Schultz subsequently obtained an additional copy of what appeared to be the same email, but with additional paragraphs in which Davis stated to only conduct a trial before court in Judge Wooten and Judge Jill Willis's court if the ADAs did not have any interest in the outcome of the case, and a what we say that is a trial before court was the only way to reasonably dispose of the case. The initial email Schultz received was redacted in efforts to hide the fact that the CCDAO did not want Schultz to know of the policies and procedures in Judge Wooten's and Judge Jill Willis's courts. They showed that the CCDAO did not like ruling Judge Wooten's was making in criminal cases. So not only were they going after Greg Willis with his nasty self, but they was going after his wife too. Boy, the Republican beef was deep. I'm not even gonna lie to you. The Republican beef was deep. Pattern of similar conduct by the CCDAO. A pattern of abuse of power and malicious prosecution for political gains plagues the CCDAO. In the time surrounding the gross misuse of the law against Judge Wooten, there has accumulated multiple examples of similar abusive conduct, including the following. Child, this is about to be good. I can already see it. All right, let's see what's going on. Collin County District Judge Greg Willis was investigated by defendant Melner and Assistant Attorney General David Grickler while Greg Willis was a candidate for the Collin County DA's position, which would be vacated by Roach. Judge Greg Willis' case was not indicted by the grand jury convened by defendant Melner. Denton County Sheriff Weldon Lucas was indicted by defendant Melner a day after the election. The indictment against Sheriff Lucas was thrown out by a judge just over 1 week later. Dallas County Sheriff Jim Boyles was indicted by defendant Melner for allegedly funneling more than $100,000 in political contributions into his personal accounts. The indictment was thrown out by a judge. The provision of the Texas Election Code used by defendant Melner does not even specify criminal penalties for the alleged violations. Dallas County Jail commissary vendor Jack Madera was indicted by defendant Melner only to have the indictment dropped. JV, we are protecting his identity, is a defense attorney who was indicted by defendant Melner for tampering with a government record. The indictment was later thrown out. Upon information and belief, defendant Melner specifically target JV because of a personal vendetta. DW is a defense attorney who was indicted by defendant Melner for tampering with the government record. That indictment was later thrown out. Post indictment procedural history. In addition to filing motions to disqualify the attorney pro tem, including a motion to remove the attorney pro tem filed by District Attorney Greg Willis, Judge Wooten filed a number of motions to quash the indictment. One of the motions to quash the indictment was filed on January 25, 2011. On March 11, 2011, in a hearing on the motion to quash, presiding visiting judge Kerry Russell denied the motion and stated in part that the state can charge anyone under any section they want and ignore the legislators' what? Intent of preventing this type of indictment against candidates and elected officials. In June of 2011, defendant White relayed an offer to Judge Wooten's attorneys that if she resigned, agreed to never run for public office again, and agreed to plead guilty to a misdemeanor election code violation to be crafted by defendant White later, they would dismiss the indictment. Judge Wooten's reelection would have been in March of 2012. Judge Wooten again declined the offer. Let me scroll up. And shortly thereafter, defendant White appeared in front of the 6th Collin County grand jury, presented no witnesses aside from Attorney General Auditor Cal Swihart, whose testimony was not recorded, and obtained what they titled a reindictment, adding the charge of money laundering. What? Judge Wooten, along with other alleged co-conspirators, was charged by indictment on July 14th, 2011, four, four for 6 counts of bribery, 1 count of engaging in organized criminal activity, and one count of money laundering, and 1 count of tampering with a governmental record. Judge Wooten's trial was held first. Spencer's trial was held second. Stacey Carey's trial was heard third, and David Carey's trial was held last. Judge Wooten, Stacey Carey, David Carey were each convicted by different juries. Spencer opted to take a plea deal and was sentenced onto probation. David Carey received 14 years confinement, serving 19 months of such sentence in a prison gang unit before his release, and the other two, including Spencer, were placed on probation. The Careys were able to directly appeal their case. Stacey Carey's case was appealed first. The Dallas 5th District Court of Appeals affirmed Stacey's Carey conviction. So that means whatever the court ruled in the lower court in County, the 5th District of Appeals just said, "Hey, we're not changing, and we believe that the trial court ruled correctly." Okay. So, however, in his dissenting opinion, Justice Kerry P. Fitzgerald offered a scathing dissent, stating that with respect to bribery charges at the heart of this case is most unusual because the state's evidence is not merely insufficient, it affirmatively negates an essential element of the bribery charges and proves appellant not guilty. Mm. Further, Justice Fitzgerald confirmed that all the other counts of the indictment would fail in their entirety as a result. Several months later, a unanimous panel of the Dallas Fifth Court of Appeals reversed the convictions of David Carey and rendered acquittals on all counts, finding that there was insufficient evidence to support his convictions on all counts. The state in David Carey case and Stacey Carey case, the OAG filed a petition for discretionary review with the Court of Criminal Appeals. The Court of Criminal Appeals granted the petition for discretionary review on each case and heard the cases in tandem. On December 14th, 2016, the Court of Appeals handed down their unanimous opinions in both David and Stacey Carey's. Okay, so the Fifth Court of Appeals did reverse convictions, and then the state ended up filing a petition for that. Okay, that makes sense now. In David Carey's case, the Court of Criminal Appeals affirmed the Fifth District Court of Appeals opinion and affirmed the acquittal on all counts. In the Carey's case, the Court of Criminal Appeals reversed the opinion of the Fifth District Court um, of Appeals and rendered acquittals, let's see, on all counts as well. In both cases, the Court of Criminal Appeals stated that there was insufficient evidence to support all of their convictions. Judge Wooten is acquitted, exonerated of each and every allegations contained in the indictment. On May 10, 2017, Judge Wooten filed her first amended application for 11.072 writ of habeas corpus declaring actual innocence as a matter of law with the 366 Judicial District Court in Collin County, Texas. On May 24th, 2017, the court granted Judge Wooten's requested relief, finding that the Texas Court of Criminal Appeals, in its decision in Stacey Stein Carey versus State and David Carey versus State, acquitted those co-defendants on all counts, which were substantially identical to the charges against Judge Wooten, finding the evidence presented legally insufficient because the allegations, even if true, were not crimes under Texas law. The court found that those opinions by the highest criminal court in the state of Texas were directly relevant to Judge Wooten's case and required the court to grant the relief Judge Wooten requested as a matter of law. The court further found that in light of Stacey Stein Carey versus State and David Carey versus State, the evidence presented at Judge Wooten's trial was legally insufficient to convict her of the following 9 felony convictions: 1 count of conspiracy to commit engaging in organized criminal activity, 6 counts of bribery, and 1 count of money laundering, and 1 count of tampering with governmental record with intent to defraud or harm. 71, it says that the court found a violation of Judge Wooten's due process rights. Good Lord. In section 4, these are the violations. Violation of due process rights. So defendants, while acting individually, jointly, and in conspiracy, as well as under color of law and within the scope of their employment, deprive plaintiff of her constitutional rights. Indeed, a judicial finding has been made that the arrest and prosecution of plaintiff violated her right to due process. Exhibit A order attached here to an incorporated inference by reference. Hold on, let me see. We're on page 19. Let me see what. Oh, I don't think there was attachments. I didn't grab them. I should grab them, but not right now. So that was 19. So defendants conducted a reckless criminal investigation, knowingly arrested plaintiff without probable cause and pursued a criminal prosecution of plaintiff for alleged conduct that was not criminal and based upon facts that they knew were untrue. Absent this misconduct, the prosecution of plaintiff could not and would not have been pursued. Moreover, the defendant continued the prosecution of plaintiff after they knew or should have known the plaintiff had committed no criminal act. Defendant's misconduct directly resulted in the unjust arrest and criminal prosecution of plaintiff in violation of her rights under the United States Constitution. They violated her constitutional rights. She suffered injuries, including but not limited to financial harm and emotional distress. Uh, the misconduct described in this count was objectively unreasonable and was undertaken intentionally with willful indifference to plaintiff's constitutional rights. And that's pretty much, I don't have to go through all of that. So we know that her constitutional rights was violated. As far as the Fourth Amendment, they acted jointly and in conspiracy. Let's see. Let me see. They deprive plaintiff of clearly established and well settled constitutional right protected by the Fourth Amendment to the United States to be free from unreasonable searches and seizures, including unlawful detention and arrest. That's the Fourth Amendment of the Constitution. Supervisory liability. Mm-mm-mm-mm. Defendants who acted in a supervisory capacity, such as defendants personally knew about, facilitated, approved, or condoned this pattern and practice of misconduct, or else affirmatively turned a blind eye thereto without taking any steps to stop it. In this way, the defendants are personally responsible for the complaint of injuries because they knowingly, willingly, or at least recklessly caused the alleged deprivation of plaintiff's civil rights by their actions and by their deliberately indifferent failure to act. This, mm, so what he wanted people to call him Judge Roach, even though you was just the DA, you had a role. You were over the whole DA's office. You the one who have the power that Greg Willis has now. Sorry, y'all, is the same power that DA Roach had at that time. And it's crazy because so we know Daddy don't like Greg Willis. I wonder if Junior likes Greg Willis. Anywho's failure to intervene. One or more defendants had a reasonable opportunity, had they been so inclined, to prevent another defendant from violating plaintiff's rights in the manner described above, but they failed to do so. Y'all knew what was going on in that office, and y'all failed to take action. It was a conspiracy to deprive constitutional rights. Defendants John Roach Sr., Christopher Defendant Melner, Greg Abbott, Defendant White reached an agreement amongst themselves to wrongfully arrest and prosecute plaintiff for false and legally untenable claims of bribery, conspiracy to commit engaging in organized criminal activity, money laundering, and tampering with governmental record, and to thereby deprive plaintiff of her constitutional rights, all as described in various paragraphs of this complaint. They were working with unknown conspirators. Good Lord. Malicious prosecution. Those defendants that I just named caused plaintiff to be improperly subjected to arrest and criminal prosecution for which there are no legitimate probable cause. Judicial proceedings were instituted and continued maliciously, resulting in injury, and all such proceedings were ultimately terminated in plaintiff's favor as a judicial finding of actual innocence. They accused her of criminal activities, knowing those accusations to be without genuine probable cause and without support in law, and they made statements to judges and juries with the intent to exerting influence to institute and continue the judicial proceedings. Such conduct violated plaintiffs' constitutional protection provided by the Fourth and 14th Amendments of the United States Constitution. Abusive process. Defendants made illegal, improper, or perverted use of the process, a use neither warranted nor authorized by the process. They had an ulterior motive or purpose in exercising such illegal, improper, or perverted use of the process. As a result of their misconduct, plaintiff sustained and continues to sustain juries, including financial harm and emotional pain and suffering. What is this? The Monell liability of Collin County. Collin County had a policy of pursuing wrongful arrests and prosecutions without probable cause and without due process. The policymaker in relation to the wrongful arrests and prosecutions pursued without probable cause and without due process was Collin County District Attorney Roach Sr. Hmm. A pattern of similar incidents of abusive arrests and prosecutions plagued Collin County during the relevant periods of this lawsuit. Indeed, multiple examples of abusive conduct accumulated under the reign of District Attorney Roach, including the following. And we kind of went, yeah, we already went through this. We know that, oh my gosh. So, District Judge Greg Willis was investigated. So, pretty much what it's saying is that District Attorney Roach abused his power under his tenure, under his supervised, whatever you want to call it. He said it's okay to go investigate and do whatever you need to do to Greg Willis, to the Denton County Sheriff, two Denton County Sheriffs, a Dallas County Jail Commissioner, and two defense attorneys. The constitutional violations in this case were the direct result of the policy, custom, and practice and general atmosphere within the CCDAO, in which political arrests and prosecutions were pursued with zeal and without consequence. The policy of the CCDAO of targeting citizens and elected officials without probable cause to believe they had engaged in any unlawful conduct was the moving force behind the violation of plaintiff constitutional rights. It is particularly important to note that the CCDAO was fully aware that plaintiff had not violated any law. Yet the CCDAO initiated an arrest, conducted a sham investigation, and pursued prosecutions of plaintiff. In doing so, the CCDAO ratified the wrongful acts of its employees, agents, and representatives involved in this case. The policy, custom, and practice of Collin County was to execute, encourage, and or ratify the arrest and prosecution of individuals and elected officials in Collin County without probable cause and without providing due process. These practices were common and widespread so as to constitute a custom that fairly represents the policy of Collin County. At the time of the incident, defendants Judge Roach Sr., defendant Christopher Melner, and Harry Defendant White were acting pursuant to a custom, policy, practice, and or procedure of the CCDAO. For years, as depicted in countless media accounts, the CCDAO has had a custom and culture of political prosecutions. Defendants' actions constitute a violation of 42 United States Code Section 1983 and of the plaintiff's clearly established and well settled rights to be free from unlawful searches, seizures, and prosecutions as protected by the 4th and 14th Amendments to the U.S. Constitution at that. Plaintiff will show that defendant Collin County is liable because a pattern, practice, or policy of constitutional violations existed that led to the violation of plaintiff's constitutional rights. At the time of plaintiff's wrongful arrest and prosecution, there was a widespread practice at the CCDAO of abusing prosecutorial powers. The practice was so widespread as to constitute the policy and custom of Collin County itself. The CCDAO had, during the relevant time period of this complaint, an informal custom, practice, or policy regarding the wrongful arrest and prosecution of individuals without probable cause because of unlawful conduct and without due process. The above practices, policies, and customs constituted deliberate indifference toward plaintiff's constitutional rights, the violation of her constitutionally protected rights, including those protected by the Fourth and 14th Amendments, was a direct and foreseeable cause of her injuries. As a result, plaintiff is entitled to recover actual damage as the matter of law. Plaintiff sues Collin County for actual and exemplary damages. The practices, policies, and customs were the moving forces behind the constitutional violations that resulted in injury of plaintiffs. Mm-mm. No absolute or qualified immunity. Let me see. It is anticipated defendants will rise or attempt to raise, a defense of absolute immunity. In this regard, plaintiff points out that defendants' conduct fell outside the actions associated with the judicial phase of criminal process. That's smart. Because if you were acting within that, then yes, you can be you have immunity not to be sued. But if you're acting outside of that process, it's fair game. And it says here, a prosecutor has no absolute immunity for legal advice given to the police, nor for administrative duties or investigatory functions that do not relate to an advocate's preparation to initiate prosecution or further judicial proceedings. I love it. I love it. And this is just pretty much saying it's all. So she demanded, oh man, at that time, due to the wrongful acts, she suffered mental anguish. She suffered lost wages and diminished earning capacity. She's entitled to punitive damages. She requested court costs and expenses, including attorney fees, prejudgment interest, post-judgment interest, and such other relief that the court deems, justly entitled. And that's it. So, do y'all know how much she ended up getting? She ended up, wait, how much? I think she ended up settling for $600,000. So I don't know. I need to do some research because I want to know if there are other lawsuits out there. So as of right now, we know about this 2018 lawsuit that paid $600,000 that came out Collin County's insurance fund. Then we hop over to 2022, where six individuals sued Collin County and they settled for 1.75 million. You would think that the people in this department act right. But baby, my legal eagle squad members, that was tea. But now I got to know how y'all feel cuz me personally, there's so many things running in my head. So we got Daddy Roach who never liked Greg Willis. We have Baby Roach who is now, the judge. Do you not like Greg Willis either? That's just one thing. That's one thought I have. Another thought, Governor Hot Wheels, really, like, y'all all literally concocted some bull ish to try to get this lady off this bench and make her life hell. That's crazy. And now Abbott is a freaking governor of Texas. People, if y'all don't get out there and vote, y'all better get out there and vote. Cause ain't no way I'm having him as a governor. This is too, it's too deep now. And what it seems like in Collin County is very conservative, right? But as we can see, there's beef even amongst the Republicans. But I see that Collin County wants a whole bunch of yes men. If you didn't take anything away from this lawsuit, I hope one thing that stood out to you. They wanted her gone because of how she was handling criminal proceedings. She wasn't doing what they wanted her to do. She was probably the fairest criminal judge, Republican judge at that time. But I'm thinking the higher the crime, the more money you get. Y'all see where I'm going with this? But I need y'all thoughts. We gotta discuss this in members. I want to know what y'all are thinking now that you have this additional information out there. And what I'm gonna do on my end, I'm about to go down a rabbit hole, and I'm trying to see what else Daddy Roach had. Like, in order for Christopher Milner to bring charges against people outside of Collin County, Daddy Roach had to approve that. He had to give you the okay. How many other people lives did y'all ruin? How many more people lives was ruined during Daddy Roach tenure as district attorney in Collin County? That's going to be my assignment for the next month. But y'all let me know what y'all thinks in the comments below. Definitely like this video. And let's chat about this. I want to hear y'all thoughts. You know, this is a members video. And from now on, what I think I'm going to do is just for members only. I'm going to give y'all the full court reading because that's a lot of work. But I think I was like, I didn't know exactly what to give y'all. And I think me reading the full court filing straight through with no interruptions, you know, I put my little commentary here and there, but just going straight through with no interruptions, I think that's the best gift to give y'all. Besides more things, but as of right now, that's what I can give y'all. But definitely like this video. Comment your thoughts. Let's chat about this. And I'll see y'all in the next video.